Welcome, everybody. Thank you for joining us this afternoon for the 7th in Conn Carey's 2015 OSHA webinar series. The webinar event today is going to cover OSHA's Severe Violator Enforcement Program, the who, what, when, and how to avoid it of the SVEP or SVEP. There's a lot of debate in the OSHA community as to how to pronounce this program, but there is general consensus among the OSHA Defense Bar, anyhow, that this is a pretty bad program. In a lot of ways, I think unlawful program, but at the very least, it is very significant in its consequence and in the way it's being applied, I think, in a fairly unfair way. I recognize most of you on the line with us today, but some of you I don't think I've met yet, so I will just give a brief introduction of the faceless voice that you're hearing over the line here, and my colleague who is joining me. My name is Eric Conn. I am the chair, founding partner, and chair of the OSHA Workplace Safety Practice Group at Conn Carey. My practice focuses exclusively on occupational safety and health law. In that context, I represent employers in inspections, investigations, and enforcement actions involving a host of the alphabet soup regulatory community out there, OSHA primarily, but also state OSHA programs, the Chemical Safety Board, the Mine Safety and Health Administration, and the EPA. I manage inspections, investigations, and also the full range of litigation matters involving OSHA issues, including contests of OSHA citations, to criminal investigations and prosecutions, and in civil litigation context, I will advise civil defense attorneys and clients on the OSHA implications or impact of OSHA regulations and enforcement actions on those civil actions. I also help advise clients on OSHA issues, help develop safety and health programs, and provide training, not unlike the event that we are undertaking here today. I'll let my associate Lindsay introduce herself, and then we'll jump right in.
Hi, everyone. My name is Lindsay Smith, and I'm an associate at Conn Carey, and I actually am an associate in both the firm's OSHA practice as well as the labor and employment practice, which I think can give me a unique perspective on some of the OSHA issues that we face. I do a lot of the same things that Eric just described. I assist him with a lot of those issues. I do help with representing and advising employers on a lot of the issues that we face in the employment and labor realm, such as wage and hour disputes, which, as I said, can also seep into the OSHA realm. In regards to OSHA specifically, I help with advising and counseling employers on responding to notices from OSHA and citations, and generally help with the inspection process and contesting citations.
All right, so you all signed up for this webinar today because you have, it sounds like, probably the same sick interest that I do in the Severe Violator Enforcement Program. I know a lot of you on here, and you've heard me talk about this program and know that I'm borderline obsessed with it and how unfair I think it is in many ways. So today what we're going to talk about is, what is this program? How do employers qualify into it? What are the consequences of qualifying into it? And this is OSHA's term in the directive for the program. You qualify into it like you've won some sort of prize. It's not much of a prize. We'll talk a little bit about the data, what types of employers, what industries, what parts of the country are getting swept up into this program the most. How do you get out? And then we'll talk about some other just interesting severe violator enforcement program issues. And we'll conclude with a little bit about how to try to avoid getting swept up into this program. So we'll start off with the pre-severe violator enforcement program world. And before SVEP, there was the EEP, the Enhanced Enforcement Program, which was a George W. Bush era OSHA enforcement program that had a similar mission to the Severe Violator Enforcement Program, and that was that it was intended to help OSHA steer its enforcement resources to the worst actors out there, those that were truly indifferent to the safety and health obligations. That program was in effect for several years, and it was widely criticized. It was criticized by employers, by trade associations, and the Department of Labor's Office of the Inspector General also was very critical of the program in the way it was being implemented. And its biggest flaws were, according to OIG, that the program was not effective at successfully identifying and addressing severe violators. And what OIG meant was, and I agree with this, is that the program was sweeping in way too many employers. The qualifying criteria was not doing a good job of carving out the truly bad actors that deserved perhaps some special attention from OSHA. And as a result of that, when they say is having a difficult time identifying and addressing, the problem was if you were identifying way too many employers, then you're not effectively focusing your enforcement resources. You're not able to focus your enforcement resources on those specific employers. So the program was not effective in allowing for follow-up inspections and additional scrutiny for bad actors if everybody was considered to be a bad actor. Ultimately, the enhanced enforcement program was retired in 2008 and replaced a couple of years later with the Obama-era Severe Violator Enforcement Program. And this program was introduced, the directive was put out there for public consumption in April of 2010, and the program became effective in June of 2010. So we're, a little over 5 years into living life with the Severe Violator Enforcement Program. As we said, this replaced the much maligned EEP, and its purpose was, and if you look at all the materials, the speeches that David Michaels gave about the program and language in the directive, its purpose is to identify and direct enforcement resources at those employers whom OSHA believes demonstrate indifference to their OSHA Act obligations. What does that mean? How does one show or demonstrate indifference to their OSHA Act obligations and therefore get swept up into this SVEP program? According to OSHA, in their directive, they have determined that an employer demonstrates indifference to their OSHA Act obligations if they commit, or really if OSHA alleges that they commit, violations in 4 buckets. The first category is any egregious enforcement action. That means if OSHA issues any citation under its egregious enforcement policy, which more or less is a willful plus. It's so bad that OSHA has decided to characterize it as egregious. It's still going to be identified as willful in the citations, but it allows the agency to break up citations employee by employee, tool by tool, machine by machine, instance by instance. And what happens there is, say you have 10 employees who are not wearing hard hats when the law says that they should be, and OSHA believes your conduct was so egregious in that area that instead of citing one PPE violation, one personal protective equipment violation for not providing and ensuring hard hats are worn, OSHA will issue 10 PPE violations, all willful, one for each employee who's not wearing the PPE. That's an egregious enforcement action, not implemented very often by OSHA, but when it is, that is essentially automatically a Severe Violator Enforcement Program qualifying citation. The second category of citations, alleged violations that will qualify you into the Severe Violator Enforcement Program, are circumstances where you have one or more willful, repeat, or failure to abate violation related to a fatality or catastrophe. So if an employee is killed on the job and OSHA issues a willful, a repeat, or failure to abate violation related to the cause of the employee fatality, that will qualify you into the Severe Violator Enforcement Program. It also covers catastrophes. Catastrophe is defined by the old injury and illness record-keeping rule, which has changed, many of you know, for reporting purposes, but the catastrophe definition for severe violator purposes remains the same, and that is a single incident that results in the hospitalization of 3 or more employees. If you have a willful, repeat, or failure to abate violation related to an event that causes the hospitalization, overnight hospitalization of 3 or more employees, that would also be an SVEP qualifying citation. The fourth category, and I'm skipping over the third one here for a reason, but the fourth category is circumstances where OSHA issues or alleges 3 or more willful, repeat, or failure to abate violations related to OSHA's Process Safety Management of Highly Hazardous Chemicals standard, the PSM standard. So if you are a chemical manufacturer, a petroleum refiner, or you work in certain industries where you have chemicals for cooling above threshold levels, there is this complex PSM standard that applies to your operations. And if in a single inspection, OSHA alleges that you've committed 3 or more willful, repeat, or a failure to abate violations of the PSM standard, that will qualify you into the severe violator enforcement program. Final category, and I saved this one for last because Lindsay will talk about later some data on this. This is the category that is tripping up most of the employers who find themselves branded as severe violators. They get there this way, and that is 2 or more willful, repeat, or failure to abate violations, alleged violations, related to a defined term, high-emphasis hazard. And these high-emphasis hazards are spelled out specifically in OSHA's directive for the SVEP. And they more or less line up with the active, or at least active at the time the directive was first written, national emphasis programs. And that includes falls, amputations. There's an amputations emphasis program that was just expanded about a month ago by OSHA. This covers your lockout, tagout, and machine guarding issues in industries where that would be a common hazard that's encountered. Excavations, primary metals, lead, combustible dust, silica, and then, so all of those that I've named already are hazards. And it makes sense. It's your high emphasis hazards relate to hazards that OSHA is really focused on. But there are 2 items in this severe violator enforcement program that are not really hazards, they are industries. And that's the grain handling industry and the oil and gas industry. These are industries that have received a lot of attention from OSHA over the last 5 years, at least the last 5 years, and therefore OSHA just dumped those into the high emphasis hazard category so that they could increase the consequences of enforcement actions in those industries. That's how you qualify into the program. How about when you qualify into the program? You've heard me talk about the severe violator enforcement program. You know that this slide is where the hair stands up on the back of my neck. I start to pound the table and I get very upset. The concept here is that employers qualify into the severe violator enforcement program just based on allegations. And this happens essentially at the very beginning of the enforcement process. I've had folks at OSHA tell me it's not the day that the citations are issued, but it is that 15th working day after they're issued. So in other words, if you go in at the informal settlement conference and resolve a set of OSHA citations to remove the qualifying criteria, you are never dumped into the program, but that's extremely rare in these severe violator enforcement cases because you're dealing with willful and repeat violations, which OSHA is want to address at the informal settlement conference stage. But essentially, the beginning of the process, when OSHA alleges that you have violated the law in some egregious way, you are dumped into this severe violator enforcement program. You're branded as a severe violator, and the consequences of the program, some kick in immediately, others can kick in immediately, but may take some time, all based on an allegation. And that's, before the employer has had an opportunity to defend itself or to prove wrong OSHA's alleged violations, or in many cases, to even present its side of the story at all to the agency. Here you are branded out of the gate as a severe violator. I want to let Lindsay talk to you about some of the consequences of qualifying into the program, because I need to calm down after talking about the timing issue there.
So So I'm going to take some time now to talk about the consequences of qualifying for SFEP, as well as some of the trends in the SFEP data. As you can tell, Eric gets very excited about this issue, so he may jump in at some point as well. But I will start by going through the consequences of qualifying for SFEP. So some of these consequences are actually provided in the directive, while others are ones that we have kind of seen throughout the process of qualifying for SFEP and then, contesting the citations associated with that qualification. So the first one you see there is mandatory follow-up inspections. So these are the inspections that occur and are required to occur by OSHA at the establishment where the underlying citations were actually issued, so where the alleged hazard actually occurred. The next one there, inspections at related facilities. So according to the directive, if you have 10 or more sister facilities within your organization, OSHA will inspect 10 of those facilities. And if you have less than 10, then OSHA will inspect all of those facilities. So a really significant consequence of qualifying for the SFEP program is that you have these related inspections that they will do automatically, even though these other establishments may have nothing to do with the hazards that were cited at that initial location. And then enhanced settlement agreements. So as with any other instance where you decide to contest the citations, OSHA cannot force you to enter into a settlement agreement. But if you do decide that you want to settle, then OSHA kind of takes the stance that you need to accept the terms that it provides. They are negotiated, but OSHA has a lot of leverage in these cases, even though at this point it hasn't proven that you actually did any of the things it alleges, or that the violations even actually existed. This can include in the settlement agreement corporate-wide abatement, as well as third-party audits. These are two things that we have seen a lot in these enhanced settlement agreements. So the corporate-wide abatement issue, under the OSHA Act, OSHA can only require an employer to abate a specific hazard at the specific location where the inspection was conducted and the violation was found. But this corporate-wide abatement basically allows OSHA to require an employer to implement a fixed improvement or fixed abatement throughout its organization, so at all of its different establishments. Thus, if one of those establishments fails to implement something that was, included in that corporate-wide abatement policy in the settlement agreement, then OSHA could actually go to that site and, if it's not there, cite the establishment for, not having implemented the abatement and potentially give them a citation for failure to abate.
And likewise, you can implement the tools at OSHA's disposal to enforce the terms of a settlement agreement at all of these locations, actions in the district courts for finding contempt. And we've even seen some instances very recently where senior managers of small, closely held companies have been jailed for not implementing abatement, for refusing to implement abatement and refusing to honor an order from a district court compelling them to take certain abatement actions. And here, this would apply to all of the locations within your organization that are covered by the corporate-wide abatement.
And then the next point there, the third-party audits. This is something that OSHA really likes and will include in these enhanced settlement agreements because of the fact that they only have, so many resources to conduct their inspections, and they can't be everywhere. So they can use this, part of the settlement agreement to basically require that an employer pay a third party to come out to the site and do an audit similar to what OSHA would do during an inspection, and then share those results with OSHA. So it's, can be almost as effective as OSHA actually coming to the site themselves and doing the inspection. OSHA really likes this tool because third-party auditors actually often go beyond, the regulatory requirements and will include things in their findings that are not necessarily required by the standards. But if they are included as a finding and that audit is provided to OSHA, then OSHA can hold the employer accountable to address all of the findings in that audit. However, at the same time, there's also some advantage to an employer in the sense that with hiring the auditor, there is some ability to influence that final report before it's actually submitted to OSHA. And then the last point here, public shaming, which...
Yeah, so before we move off this slide, and Lindsay mentioned this, and this ties into, what we just talked about on the previous slide about timing. All of these elements of the sort of punishment for being a severe violator kick in the moment that OSHA issues the citations. We have seen instances where the mandatory follow-up inspections, not the mandatory follow-up inspections, where the related facility inspections will actually begin even before the citations are issued in an SFEP case. OSHA knows they're about to do it. They've run it up the ladder to issue the citations. They think there's a systemic issue within the organization. So you see 2, 3, 4 inspections starting at sister facilities either right before or right after the citations are issued. And the justification, the probable cause for opening inspections at these other facilities is your qualification into the severe violator enforcement program, when the reality is that's just an allegation that OSHA has made that they haven't proven. But there they are at your doorstep conducting additional inspections. The settlement terms, they've accused you of being a severe violator and therefore negotiate with you in a different capacity that they would other employers. And then the public shaming element that Lindsay's going to talk about in a moment really, kicks in the day the citations are issued, and she'll talk a little bit about that. There is a question that's come in, though, that gets to this timing question, and that is, has the initial point of entry into the severe violator enforcement program been challenged yet? And so let me put it this way. There's not been a legal challenge to that yet, but certainly there's been, the leadership within OSHA in Washington, D.C. has been challenged through discussions, through, I served on a panel with the director of the Directorate of Enforcement, Tom Galassi, and we talked about this issue, and I challenged him on a couple of timing issues. Another one we'll talk about in the exit process. Talked about how unfair this was, how unlawful I thought it was, that there's due process issues, Administrative Procedure Act issues here. And what I mean by that is there can really be no question that these elements of the consequences of qualifying into the program are punitive. They are intended to be punitive. And if they are punitive and they're being implemented before you've had your day in court, that violates due process under the Constitution. It also violates the Administrative Procedure Act, which describes for agencies, how they can set and determine punishment available for violations of regulatory standards. And in that circumstance, Congress determined, and OSHA somewhat determines through regulation, what punishment is available for employers' violations of standards. That punishment is, civil penalties of $7,000 for serious and other than serious violations, and civil penalties of $70,000 for repeat and willful violations. It's not, regulation by inspection, sister facility inspections. It's not corporate-wide abatement requirements, third-party audits, negative press releases, and things like that. But here, OSHA is doing all of that from the outset. So I've, expressed to OSHA how unlawful I think this is. Their response has been, look, this is just a policy. This is just a program that helps us redirect our enforcement resources. It's not a law. It's not a regulation. It doesn't give us any new authority. So we think we're allowed to do this. I disagree. I think they have created new authority for themselves, and I think a challenge has some possibility of success. We just haven't found the right plaintiff to challenge it yet. Somebody who is perhaps entered into the program under obviously flawed citations and who is subject to multiple sister facility inspections right out of the gate would be a great candidate to challenge this policy, this rule, and I think there could be some success with that.
All right. So another significant tool for OSHA and an important consequence for employers is that employers qualified into the SVEP receive public shaming through many different sources, but most apparently through the press releases from OSHA. So OSHA issues press releases when citations are issued, but the press releases for SVEP qualifying employers are particularly egregious. And again, these statements are made and these press releases come out before any allegations are actually proven. And oftentimes, the way that they are stated, it sounds like fact that an employer has failed to do something, or a fact that an employer is not providing the required safety measures to its employees. These press releases usually contain a specific inflammatory quote from a senior OSHA official, often the area director, or from a DOL official. And like I said, these quotes frequently accuse the employer of failing to provide safe work conditions, or, a lot of times just flat out ignoring the safety of their employees, even though those are simply allegations and have not actually been established by OSHA. It may also accuse employers of habitual failings pursuant to repeat violations, which, as I'll discuss a little bit later, are the basis for a lot of SVEP qualification. The release also includes the name of the employer, so the employer is immediately linked to the allegations against it and the egregious acts that are presented by OSHA Act. Another source of public shaming is a log that is maintained by OSHA of the employers in SVEP. This log is maintained on its website, and it has the name of the employer, the reason that it qualified for SVEP, among other information that is significant to the employer and to the inspection. The public can access this log, and that includes employees, it includes unions, anyone can access this log. And a significant part of this log is that it's presented in an Excel spreadsheet. So this is actually a searchable document, so that an employee looking at the log, a union, could easily search for the particular employer and also organize the log in a way that makes it very easy to find the relevant information. This tool could also be used by competitors, or it could be used by plaintiffs' attorneys who are looking for, potential personal injury lawsuits. Those can often be related to SVEP qualifying citations, and we've seen that a lot with some of the cases that we've worked on.
There's an interesting question just came through in the chat function in the bottom left corner of the screen. Somebody asked the question, is there a formal notification to the employer of SVEP entry? And I bring that question up at this point because there is not a formal notification. The citation itself is not going to use the word severe violator or severe violator enforcement program or SVEP qualifying or anything like that. The notification that you get is the notification that the public gets. You're going to see that press release the day the citations are issued, and you're going to be called a severe violator in that press release. Your name is going to end up on this log on OSHA's website within a quarter. They update the log quarterly. So within a quarter of your citations being issued, you will see your name appear on this log. That's how employers are notified. It's not any sort of formal way, anything that looks like something that you can challenge like a citation does. So that's how you hear about it.
It is actually interesting, I think, that point, because OSHA doesn't specifically notify the employer, yet it will lay out in explicit terms in the press release that the employer has qualified for the severe violator program. And these press releases are actually also maintained on OSHA's website. So even if you are an employer who originally qualified for SVEP, maybe throughout the process of contesting the citations, through the hearing or even in a settlement agreement, you actually no longer qualified for SVEP, that press release remains on OSHA's website. They go back to when SVEP first went into effect in 2010. And so anyone who does, who searches the site and finds that press release, there's no indication on there that an employer has been removed from the program. They can still see that at one point the employer qualified, and there's nothing to indicate any difference in what the press release stated at that point. And OSHA never issues anything that says that an employer no longer qualifies for the program or has been removed from the program.
So an employer, if you are removed from the program, you will be removed from the log, but the press release stays out there forever.
Right. There's nothing that explicitly identifies to someone searching, other than if they happen to look at the log again and notice that someone was no longer there. There's nothing explicitly released by OSHA that says that an employer no longer qualifies or has been removed from the program.
Or was mistakenly qualified to begin with, which is what we see most often.
So along with these consequences, these direct consequences of the program, there's also some direct consequences that are important to consider and important to be aware of, if ever you should qualify for SVEP. So the first here, harm to the company's reputation. The public shaming that occurs, all of the information put out there about the employer, we even had a chance to contest the allegations against it, could definitely cause harm to a company's reputation. Again, that information is all public, so it's also accessible to your customers and clients. And customers and clients may decide that, it's not good for them to be associated with an employer that has qualified for the SVEP program. So an indirect consequence of that is that there could be loss of business, loss of customers, and loss of clients, as well as maybe, potential clients and potential customers choosing to go elsewhere for their needs. There can also be defection by current employees. They have access to this information, and a lot of times they will be a part of the inspection and a part of, the investigation into the citations that actually qualify the employer for SVEP. So they could choose to leave the employer if they perceive it as being an unsafe environment based on OSHA's depiction of the workplace there. This could also, again, hurt prospective employees. It could hurt recruiting efforts because this information is available to prospective employees as well. We've also seen or increased interest rates on loans that employers may attempt to get because of their qualification in SVEP, as well as an increase in insurance rates or a loss of coverage altogether because of the risk that may be perceived associated with an employer that qualifies for SVEP.
Yeah, and I've dealt with both of these issues directly on behalf of some of my clients, where either the bank or the insurance company have just come out directly and said that, look, we perceive there to be greater risk here now, and it's greater risk in terms of the security of the loan or greater risk in terms of what they're insuring based on, OSHA, federal OSHA, the agency deemed to be expert and with jurisdiction to evaluate the safety and health of our workplaces, that agency has come out and said that not only are you not in compliance, but you're the worst of the worst. You're a severe violator, and that increases the perceived risk by these lending organizations or insurance companies. And I've seen one instance where a small local bank was literally about to drop the line of credit for this small business, and which would have put the company out of business. We were able to go in and convince them to say, look, let us tell you what this program is, how OSHA is applying it, why this is just based on an allegation. We can show you why we think the allegation is wrong. And in any event, it's not really carving out this really small universe of bad actors. It is resulting in a great many employers getting swept up into this, and we'll talk about that in a second. So we were able to avoid that in that circumstance, but we've seen this come up several times.
And then finally at the bottom there, SVEP designation could be used by unions for purposes of organizing. A union could use the perception of unsafe conditions to promise employees that it will vie for safer working conditions that the employer is not currently providing. And as I mentioned prior, it could also be used by potential plaintiffs' attorneys to support a personal injury claim against the employer. So next, I'm just going to kind of go through the data and the trends that we've seen based on statistics associated with the SVEP program over the last 5 years. So first here, a really significant slide, I think. This shows, SVEP has been in place for just over 5 years now, and this shows that there have already been 778 total SVEP cases. So this averages out to about 12.4 new cases a month. Another way to look at that is that there is one new SVEP qualifying employer almost every other business day. So OSHA has really kind of painted this program as something that is used in the rare circumstance for the really egregious offenders. And this data, I think, shows that this simply isn't true. There are a lot of employers that are qualifying for SVEP who probably should not be included in the program, who are not the egregious, bad actors that OSHA had the intent of including with its directive.
And that's one thing that I talked about that panel that I sat on with Tom Galassi. During that event, sort of his entire portion of the presentation was, everybody keeps complaining about this program, but it's no big deal. And he emphasized over and over again what a small, minuscule group of employers are getting qualified into this program. And he had a slide, it was a pie graph that showed, all of the employers that are inspected, all of the employers that are cited, and this tiny little sliver that represented the severe violator enforcement program. But the reality is, somebody's getting qualified in there every other day. I don't see how they could characterize that as no big deal, because it is a big deal, and the way they're implementing it makes it an even bigger.
This is also a large number considering, like we've been talking about the purpose of the directive. It's supposed to be to focus resources and inspection on a particular group of employers who OSHA considers to be, these bad actors, and who have demonstrated indifference to employee safety, and these numbers simply don't reflect that reality. This next chart depicts a breakdown of SVEP qualifying cases by industry. As you can see, the construction industry is the source of over half of SVEP qualifying cases, approximately 60%. Another big chunk is the manufacturing industry, which makes up just under 25%. And this is a really significant one, especially for general industry violations, because the term manufacturing, as it's used for this purpose, is based on the NAICS code and the SIC codes. And they categorize those manufacturing operations over a broad range of business activities. So there could be some business activities that an establishment of the employer performs that the employer might not consider manufacturing, but according to the NAICS code or the SIC code, it would actually be classified as such pursuant to these codes. The grain industry is another significant source of employers that are deemed severe violators that qualify for the program, and has been one that has been growing over the past few years. Not surprisingly, these are the industries where OSHA has also had the most active national emphasis programs, as Eric kind of discussed earlier. These NEPs tend to line up with the hazards deemed high emphasis hazards by OSHA in its SVEP directive, and these are the industries where OSHA is doing the most inspections. And then this next slide here depicts the area offices that are establishing the most SVEP qualifying cases. This map depicts the breakdown of the SVEP cases, by region. I don't know why I'm having some difficulty speaking right now. You'll notice that Region 5 has significantly more of the SVEP qualifying cases at 31%. Specifically, Ohio and Illinois tend to dump a lot of employers into SVEP because of the industry in those areas, as well as just the personnel that tend to work at the offices in those areas. They have taken a broader view of what sort of hazards should be classified as repeat or willful pursuant to the SVEP directive. The next closest region is Region 2, and that has about 20% of the SVEP qualifying cases. Several of these regions are below 10%, and those regions with much fewer cases are those that are mostly made up of state plan states, where SVEP cases may be referred to federal OSHA or where the state may have established its own SVEP-like program, but they are not having as many employers that they are considered to qualify for the SVEP program. And then this is actually Eric referred to earlier when he was going through, how employers qualify for the program. And it's really important because it shows, that 68% of the employers that qualify based on that third category, the 2+ willful, repeat, or failure to abate citations related to high emphasis hazards. This is by far the easiest category to qualify, which makes sense considering that it is the largest one as far as how employers qualify for the program. Because many inspections, as you'll see later in some data that we have, result in at least one repeat violation. Furthermore, OSHA continues to add new standards considered high emphasis hazards to the list provided in the directive. So after the directive was already passed, OSHA did add the grain handling industry and the hazards associated with the grain handling industry. And the most recent has been upstream oil and gas hazards, which OSHA added in 2015.
So I want to add a couple of points here. This is, and you'll detect the theme here that we think this program is not focused in the right ways. When you think about the idea that SVEP is intended to identify and carve out those really indifferent employers who are indifferent to safety and health, you would think you'd be finding many more of these egregious cases being the ones that trigger SVEP qualification, or willful fatalities, willful violations related to fatalities. That would be an area where the most SVEP cases are coming in, but the reality is that they are mostly in this high emphasis hazard category. And the true reality that Lindsay's going to talk about now is that not only are they not in the in those other categories, they're really not even involving willful violations at all.
Exactly. The purpose of SVEP, again, is to identify those employers who are indifferent. Specifically, the directive states indifferent toward their OSHA Act obligations. And indifference is associated with a willful violation. It has been interpreted as part of the definition of a willful violation. Yet, a repeat violation does not have any aggravated conduct, doesn't require any aggravated conduct or intent, and this is the basis for, as you can see, over 75% of the cases that are SVEP qualifying. An employer can get a repeat violation just by having constructive knowledge of the hazard. That's all OSHA needs to prove to establish a repeat violation where a similar violation has already been held against the employer. Additionally, a repeat violation could be based on any prior violation, including other than serious violations, if it was related to a high emphasis hazard. This reality can be particularly problematic for large employers who have numerous establishments and employees. Two employees at completely unrelated establishments that are within the umbrella of the same employer, could decide to remove a guard or decide one day to not use the fall protection that's been required. And this can be sufficient to establish that a repeat violation has taken place within this employer's establishment and be enough to put that employer into the SVEP program if it receives 2 or more of those repeat violations attached to a high emphasis hazard. On the other hand, an employer who receives numerous willful violations that just happen to be associated with non-high emphasis hazards as explained in the directive wouldn't qualify, which just, seems ridiculous. These are the types of employers, the ones that are committing repeated willful violations that it seems, based on the intent of the directive, OSHA was aiming for, yet it is going after a lot of employers who simply have these repeat violations that do not necessarily indicate any semblance of a bad actor.
Right. I mean, the concept of a repeat violation here is, remember that an other than serious violation can serve as the basis for a subsequent repeat violation. So you could have back-to-back other than serious violations, multiple of them, and you become a severe violator. There is no aggravated intent, no aggravated conduct required to characterize a violation as repeat, yet that is the vast majority of qualifying criteria that are getting people swept up into this program that has such dire consequences. I think that's wrong. I mean, the purpose of this thing is to find those who are indifferent, and somebody who has, maybe 3,000 sister facilities around the country. You're a retail store with thousands of locations, and you get the same relatively minor violation 2 times, you've qualified into the severe violator enforcement program. Somebody else out there, for example, who has committed 5 willful electrical safety violations is not a severe violator because that's not a high emphasis hazard, but 3 little piddly repeat violations where it was different managers that had no more heightened awareness than any other employer out there, and were not behaving in any sort of egregious way. They are severe violators. So I think it's a broken system in that regard.
So it's not so surprising that repeats have been the basis for a lot of SVEP employers, or a lot of employers qualifying for SVEP, because OSHA has been in recent years seeking out and citing more repeat violations. In fact, it's made several policy changes to make repeat citations easier to find and to cite. And this slide shows 3 of those changes that has made it a lot easier for OSHA to cite employers for repeat violations. So in the past, OSHA has treated workplaces as individual. So those companies that had several different establishments, it would treat each establishment as its own individual workplace. Now OSHA is treating these workplaces as one employer in a corporate family, allowing these citations that are found at one establishment to be used as the basis for a repeat at a completely separate, unrelated establishment, as long as it's within the same corporate family. OSHA used to limit its review of the employer's OSHA records to 3 years. So when these inspections occur, OSHA will often pull the employer's records of prior citations, and it used to be it would only limit that to 3 years. Now that look-back period is for 5 years. So OSHA will pull records up to 5 years to see if there are any citations in the employer's past that could qualify it for a repeat violation in the current inspection. Then finally, it used to have more of a reactive philosophy. It would be less likely to do these sort of follow-up inspections within a few years of citing a particular employer. But now that philosophy has changed. It's much more proactive. And they are specifically choosing to come back to employers that they have already inspected to see if they can find any additional violations. And, all of these are very much important in establishing that a repeat violation has occurred. And then this last slide here is really significant because it depicts the fact that other characterizations have remained consistent as far as how they are cited by OSHA pursuant to an inspection, but repeat violations have been consistently on the rise. They have consistently made up a greater percentage of the citation characterization. Thus, you can see that the repeat characterization is significant, not just because of the $70,000 potential penalty, but because of these really important implications it can have for the employer qualifying into the SBEP program.
All right, so we've talked a little bit about how you get into this program and all the horrible things that happen if you do. So let's talk about how you get out. I'm sure there's a great interest in that. The interesting thing about sort of the exit criteria for this program was that this SFEP program was introduced in 2010, and it wasn't for 2 years that OSHA even introduced an exit criteria at all. For the first 2 years of the program, it was literally the Roach Motel. You check in, but you can never leave. And there was much clamoring by industry, myself included, pushing and lobbying at the agency to say, look, if you're going to have these types of consequences and this much public branding and shaming involved in the program, there has to be an exit ramp. So in 2012, OSHA introduced a formal set of exit criteria for how you get out of the severe violator enforcement program if you are confirmed to be a proper SVEP employer. In other words, your qualifying citations become a final order and you are effectively in the program. This is how you get out. And you will hear, this is another area that I get very animated about this program that I disagree with pretty vehemently. I think it is effectively an impossible set of criteria. 3 of the criteria are very doable, but one of them I think is what makes this an impossibility. So first of all, the exit criteria requires you to serve basically a probation period of 3 years from final disposition. And this is, I already get upset when I talk about this because OSHA qualifies you into the program based on alleged violations, not final disposition, based on allegations, but they don't even start your exit clock. They don't even start your probation period until final disposition. There is absolutely no way to reconcile those two things. It is just a gross miscarriage of justice there. But what happens is if you challenge your citations, a process which can take years, and ultimately you lose, or ultimately changes are made to the citations, but they remain an SVEP qualifying citation, and that process has taken you 3 years, your exit clock hasn't even started yet. So technically, you're in the program for a minimum of 6 years under those circumstances. So it really punishes employers for exercising their rights to challenge OSHA citations. But in any event, the exit criteria are a 3-year probation period from final disposition. During that 3-year period, employer shall have abated all of the violations from the qualifying citations. No big deal. I would totally understand and expect that to be one of the criteria. You will have to have paid all of the civil penalties associated with the qualifying citations. That makes perfect sense. And you will have to have satisfied all the terms of the settlement. That makes some sense to me, but I also have seen several of these settlement agreements in the SVEP universe where there are long, drawn-out periods. For example, you'll commit to take an action, annually for the next 4 years or for the next 5 years. And if you've signed up to take some action that extends over 5 years, that necessarily extends your stay in the SVEP program for the life of that settlement agreement. So I understand where they're coming from with all of those elements. It's this next element that I think makes this exit criteria a myth, and that is that the employer cannot commit any related subsequent serious violations. Remember that it takes willful and repeat violations to qualify into the program, but serious violations keep you in the program and basically restart a new 3-year clock. And even if you're able to run the gauntlet of all of those requirements, there is this vague discretion of the regional administrator for who gets let out of the program. And they don't identify what criteria the regional administrator might consider other than meeting these criteria. So there's this, this vague additional requirement there. But I want to get back to this focus on serious violations. Serious violation keeps you in the program. This data point is one of the scariest that I see when I talk about OSHA enforcement, and that is that basically 75% of the time that OSHA comes into your workplace, they are going to issue a citation. Only 26% of OSHA citations are found to be in compliance. Every other inspection results in at least one citation. And when OSHA does issue citations, almost all of them are at least serious. Serious, repeat, or willful make up 85% of all citations that are issued. So let's think about the context here. You are an employer who OSHA considers to be a bad actor. They have already branded you as a severe violator. Under the severe violator program, they are going to conduct mandatory inspection at the location where they already cited you and qualified you into the program, and up to 10 inspections at sister facilities, going into those inspections with the mindset that you are a bad actor. Every employer, even those that aren't considered bad actors, face an uphill battle of 75% likelihood of getting cited, 85% of citations at least serious. It seems impossible to me that with that barrage of inspections and that history of enforcement by OSHA across all employers, that it is virtually impossible for an employer to go 3 years, 10 inspections, and not get a serious violation to reset the clock. And the data here bears this out. We are, 5+ years into the severe violator enforcement program. Over almost 800 employers have initially qualified into the program, and exactly 0 have gotten out following that exit criteria. So, this is not just my jaded defense lawyer's view of this. The reality is nobody is getting out following that criteria. Now, that's not to say you can't get out, because there is two surefire ways to get out. One is don't get in. You avoid qualifying citations. You implement an effective safety program such that it would be, very, very difficult for OSHA to bring those willful violations, and you're taking the steps necessary to ensure that, once you're hit once, that you don't get those repeat violations. But let's set that aside and say OSHA has issued SFEP qualifying citations. How do you get out at that point? The only way to get out that I can tell, that really the best advice I can give, is that you fight those citations as hard as you can to get the qualifying criteria changed. And that might be through a settlement, and it might be through a decision by an ALJ or by the review commission or by one of the circuit courts. But you will be extricated from the program if before your citations become a final order, the qualifying characteristics of those citations are changed. Either the citation that got you in is withdrawn, or the characterization that got you in, it's willful or repeat, are downgraded from willful or repeat to serious or other than serious. If you're able to do that, you will get out of the program.
Or if the willful or repeat characterization can be attached to a non-high emphasis hazard.
Right, and we'll talk about some of the strategies there, but that's the crux of it is, to get out, you've got to attack the qualifying citation. And so we'll talk just a little bit about some exit data here, and then get into some strategies and other issues. We've talked about this number. It looks like as of the October update, there are 778 SFEP cases, and that means that, whether they're still in there or not, there are 778 entries on the SFEP log. That means OSHA qualified into the program 778 employers over the life of this program so far. 112 of those cases remain actively contested, meaning they qualified into the program based on alleged violations that were contested and remain contested. And those 112 employers, many of them could have been wrongfully accused. That's why they're challenging their citations, and yet there they are, branded as a severe violator. Already, over the life of this program, more than 150 employers have been extricated from the SFEP because their original citations were wrong. They challenged the citations and either through a settlement or through an adjudication have proven wrong, or OSHA has accepted and agreed that they were wrong in the issuance of the initial qualifying citations. That is approximately a 20% error rate. And think about that. OSHA gets it wrong at least 20% of the time, and yet they are qualifying you in and implementing these harsh punitive elements upon the issuance of violations, upon allegation, but they're getting it wrong 20% of the time. That makes this even more egregious, in my opinion. Another thing, thinking about this timing issue, there is an employer presently listed on the log who has been there for 4 years and 11 months that has an active contest. That means they were dumped into the program based on OSHA's allegation, and their process of whether OSHA was right or wrong has still not played out. They've been dubbed a severe violator for 5 years. All of that public shaming, all of the potential for follow-up and sister facility inspections, and still during that entire period, OSHA has not actually proven that that employer violated the law at all, let alone in the egregious ways that would properly characterize somebody as a severe violator. And then the last number I just mentioned to you, 0 employers have gotten out following OSHA's official formal exit criteria. So this a program obviously that has some problems. We'll talk about some other unique issues related to SFEP and then some strategies, and we'll let you all go and enjoy the rest of your afternoon. If you're not have to be balled up in the corner, upset about this like I might be when I finish talking about it. Some other issues here to think about is that this is a federal OSHA program, but like most enforcement programs put out by federal OSHA under this administration, they have mandated that the federal OSHA approved state OSHA programs develop and implement an equivalent program. And that equivalent program is one that must include enforcement procedures for identifying and taking action against employers who demonstrate indifference to their OSHA Act obligations, and a part of the program needs to include some method, some procedure for making referrals to federal OSHA and for responding to referrals from federal OSHA about severe violators so that these sister facility inspections can take place. Now that's what the directive says, and that is technically what is required of the state plans. But from a practical standpoint, my experience is that these state plans are not really doing this. It is extremely rare, I have found, that employers are actually qualifying into the SFEP and showing up on OSHA's log in the state plan states. Somebody asked earlier how the OSHA region that included California could have only 1% of the SFEP qualifying cases. It's because that region includes, I think, California, Oregon, Washington, basically exclusively Nevada, exclusively state plan states. And even though OSHA has required the state plans to adopt an SFEP or SFEP-like program, we just have not seen that implemented, practically speaking. What we have seen, however, is that if there is an employer who qualifies into SFEP in a federal OSHA state, that federal OSHA is making referrals to the state plans where that employer has sister facility operations, and inspections are happening out in those state plan states. That is a critical part of this SFEP program, is the nationwide referral program, and that has been where I think OSHA's attention, federal OSHA's attention has been in the state plans, is making the state plans do some of their dirty work for the employers that they have qualified in federal OSHA states. Some other interesting issues related to SFEP, extraordinarily high, relatively high contest rate, where SFEP cases are contested about 50% of the time. I think it's like 48.5% of all SFEP cases up to this point have been contested versus a national contest average of 8%. To me, this jumps out because of the timing issue. We are punishing employers out of the gate for violations that are getting contested about half the time. strikes me that there some caution and some making sure that the agency was right would be appropriate in a setting where half of the citations are being contested. Approximately 30% of SVEP cases that you look at on the log remain under active contest. Some for more than 3 full years. One we saw that's almost 5 full years. So these are employers who are out there represented to the public as bad actors. 30% of them have active contests going, challenging the underlying citation. Some other interesting issues. The data shows that it's a disproportionate targeting of small employers. I think it's 75%, approximately 75% of employers with 100 or fewer employees make up the body of this severe of the group of bad actors swept into the program. 50% with 25 or fewer employees. And, you know, there's 2 sides to this argument. OSHA would come out and say, well, it's not unexpected that smaller employers are violating the law more often. And I agree with that. I think small employers lack the same resources that their larger competitors have. But doesn't that suggest that rather than a harsh punishment, we should be perhaps considering some compliance assistance? What I see is that smaller employers are not willfully or indifferent to violations or to their obligations under the safety and health regulations. It's that either they don't know what their obligations are or that they don't have the resources to comply. So rather than slapping, you know, several $100,000 or $1 million penalties on them and a barrage of inspections, how about some compliance assistance? But you can see where the SVEP employers are coming from here. Just real briefly, I want to talk about another new consequence or potentially new consequence of qualifying into the Severe Violator Enforcement Program, and that is if you are a federal government contractor, there is a proposed rule that is working its way through the rulemaking process in furtherance of President Obama's Fair Pay and Safe Workplaces Executive Order. And this is the Fair Pay and Safe Workplaces proposed rule proposed by the FAR Council and the Department of Labor, wherein employers are required to disclose to the contracting officer of a federal government agency during the contracting process, during the bid process, and throughout the life of the contract, certain types of labor law violations. And the purpose of the rule is that if you are an employer, an owner or operator who has a bad history, compliance with labor laws, including specifically OSHA regulatory compliance, that if you are one who repeatedly violates the rights of employees in this context, you don't get government contracts. And in the clear, proposed rule, they say that the focus of the analysis of your labor safety, of your labor record, including your OSHA record, is that those who have violations or those violations that are most concerning and most likely to result in debarment or disqualification from certain contracts are those that have the greatest bearing on the assessment of the contractor's integrity to do business. Those include pervasive violations. You can see they include serious, willful, and repeated violations, but pervasive violations. And pervasive violations in the OSHA context, I am sure, are severe violator enforcement cases. So if you are swept up into SVEP, this has a very significant likelihood of resulting in one of these outcomes in a federal government contracting context. Talk about that more offline if you're interested in this, but we've been working with a coalition of employers to try and either kill this rule or improve this rule, and I'm happy to talk about this with you in more detail. But now that we're all terrified of what this rule means and understand how we can find ourselves tripped up and get into it, let's talk about some strategies for how to avoid this. And we've hit on this just a little bit, but thinking about how the most common way to get into the program is by repeat violations of a high-emphasis hazard. You need to think about how to avoid repeat violations. And if you are an employer that operates multiple facilities, you are uniquely susceptible to repeat violations. So it is critical that if you have multiple establishments, that you enhance your safety-related communication between your sister facilities. Each facility within an organization needs to be aware of any OSHA activity at one of its other facilities. So if citations are issued, or 5A1 letters are issued, or recommendations from OSHA or recommendations from a OSHA consultation program are made at one location, the rest of your facilities need to understand that, because you could be set up for a repeat or willful violation based on that conduct, based on that interaction with OSHA at another facility, and then you need to act on it. You need to make sure that you're correcting similar issues identified by OSHA at each location, a great way to avoid repeat violations. Likewise, if you are a company that acquires another company, various different ways, OSHA has been trying to apply successor liability to employers. In other words, you can be cited as a repeat violator based on violations of a predecessor operator for a company that you've acquired, and in some instances at a location that you acquired, even in an asset transaction. So I think it is critical that if you are in the business of acquiring, merging, or acquiring through asset or debt transactions, that you are evaluating the safety record of the location or the company that you are succeeding or acquiring. Evaluate their past violations, their past abatement commitments, and their past audit and other recommendations to make sure that you're addressing those so that you're not set up for repeat and willful violations based on the conduct of an entity that OSHA may consider to be your legal predecessor. Specific strategies, though, once a citation is issued, either the initial citation and you're trying to avoid the future repeat, or you get in the mail from OSHA a SFEP qualifying set of citations. Your goals are to get these citations withdrawn, because if they're withdrawn, they can't serve as the basis for a repeat, or if they were qualifying citations and they're withdrawn, that's your way out of the program. Modifying the characterization. This really applies only to the SFEP qualifying citations. Get SFEP qualifying citations, and they're qualifying because they are willful or repeat violations related to a fatality or related to a high emphasis hazard, and you can get those downgraded from willful or repeat down to serious or other than serious. You would be extricated from the program right in that instance, so that's a potential strategy in that circumstance. I say it's only in the qualifying citations because we see a lot of employers out there get excited about reducing a serious violation down to other than serious, and I don't find that to be that much of a reward, because the reality is an other than serious violation can serve as the basis for a repeat violation just as easily as a willful repeat or serious can. So if you're dealing with your first set of citations, you need to think about, is this related to a high emphasis hazard? Is this something that's likely or potential to be repeated again anywhere within my organization? And if so, your focus should not be on getting it lowered from serious to other than serious. It should be on getting it withdrawn or getting it changed in some way to make it less likely to be repeated. We have seen some instances where multiple willful or repeat violations have been grouped, and by grouping them, it has gone down from 2 or 3 willful violations down to 1, and that would be a way to extricate yourself from the severe violator enforcement program. So another strategy to consider in settlement. Something else might be to accept alternate cited standards. So if you're cited under a lockout tagout violation, and you can somehow adjust that to be an electrical violation, you've removed that violation from a high emphasis hazard, and it can't serve it. It's not a qualifying citation. A repeat of it also could not become a qualifying citation in the future. And then finally, modifying violation language or the date of the violation in settlement may be a way to extricate yourself from the program. If, for example, you've qualified in because you had a willful violation related to a fatality, and you change the date of the violation to a date before or after the date that the fatality occurred, you would be able to properly assert that this violation cannot relate to a fatality because it was alleged to occur on a date different from the fatality, and that may be a way to extricate yourself from the severe violator enforcement program. So it requires some creativity, but the idea is that in settlement or through litigation before an ALJ or the review commission, you can make changes to the underlying citations in a way that can get you out of the program. And I think this is perhaps a repeat of what I just covered. So with that, I'm going to open it up to some questions, and I see that we do have some already in here. There's a question about a limit of time between the violations to serve, as the basis for a repeat violation and as SVEP qualifying. And Lindsay talked about that a little bit, that the policy that OSHA follows to issue repeat violations is a same or substantially violation within 5 years of the original violation. That's just a policy, and I have seen OSHA go longer than that before. So 5 years and 6 months, they'll say, it's close enough, we'll call it repeat. But to dig a little bit deeper in that question, one thing that the SVEP directive does make clear is that the multiple repeat and multiple willful qualifying criteria under several of the buckets has to occur in the same enforcement action. So it is not the case that a willful violation in 2013 related to a high emphasis hazard and then a new inspection at a different facility that results in one more willful violation of a high emphasis hazard a year later. OSHA does not combine those two and say, aha, we've got two willfuls related to a high emphasis hazard, now you're in there. The repeat and willful violations have to arise in the same inspection to qualify you for SVEP in that instance. There's another question here about which state plans are out there implementing some version of the SVEP. I think this is a little bit more complicated than that because the directive mandates that all of the state plans implement an SVEP or SVEP-like program within 6 months of OSHA's program. So technically, I think they all have something. I just, from a anecdotal standpoint and from a practical standpoint, I'm just not seeing the state programs doing anything with it. I don't see new employers cropping up on the SVEP log very often from state program states. So I think it's technically they're out there, but I think the role that they're playing is just doing referral inspections from OSHA, even though they're supposed to be doing otherwise. How long does it normally take to resolve a citation that is wrong? That's a really terrific question. And I mean, it varies greatly. There are some citations that are wrong, based on just a misunderstanding of the facts, that you could go into an informal conference within 15 working days and show OSHA a picture or show them a record that proves that some training occurred or something like that, and prove it wrong at the informal conference and it goes away. In my experience, these SVEP cases are not like that. Most SVEP cases, in fact, will qualify for what's called the mandatory settlement proceeding process, in which case, before the actual litigation process even begins, you go through essentially an administrative law judge-led mediation process. And usually you don't get to that mediation until, I'd say, about 6 months, roughly 6 months after the citations are issued, in which case you are trying through a mediation process to make major changes to the citations. Sometimes that works, sometimes it doesn't, and you have to continue on the fight. If you continue on the fight, usually it is more than a year before you have your case is heard by an ALJ. The decision by the ALJ might not be for another year after that. We've seen cases then that get appealed up to the OSHA Review Commission, where the OSHA Review Commission doesn't even hear it. You don't see a decision from the Review Commission for a decade. That's the outlier, but the Dayton Tire case, a really controversial case involving many willful lockout-tagout violations, was decided by the D.C. Circuit by the Review Commission 12 years after the conduct that was the subject of the citations, and then the D.C. Circuit was appealed to the D.C. Circuit, who heard it and decided it, much quicker than the Review Commission. But we're still talking, more than a dozen years after the conduct that was the subject of violations. So it can go on for a very long time. I would say the average period from citation to a decision by an ALJ is, pushing 2 years. And all that time you were in the program, and if ultimately you prove wrong major components of OSHA's case, but there's still a qualifying criteria at the end of the adjudication, your exit clock then starts, so you get the gift of a few extra years in the program. So we're working on that. I can tell you that that was one of the issues I pushed very hard on the Director of Enforcement, that look, if you're going to qualify people at allegation, which you shouldn't do, but if you're going to do that, you should start the exit clock at that same time. And he said that had some appeal to him. He was taking that under advisement, and he would get back to me. He indicated at one point that they were most likely going to implement that change, but it's been 2 years now, and I haven't seen it, so I'm not holding my breath.
I think another thing too that can contribute, especially to coming to final terms, correcting an incorrect citation, especially with a willful or repeat characterization, is that OSHA gets a lot of pushback for reclassifying those types of citations. They get pushback from higher-ups within the administration as well as from the public. So they can be sometimes really tentative about being willing to recharacterize these types of citations, even if you can show that really the characterization is wrong. So that can also contribute to the time that it takes to get those types of citations resolved.
Right. I'm not seeing any more questions at this time, but most of you here I know well, and I think you know that I'm a big OSHA nerd. I love talking about this stuff. You should always feel free to reach out and ask any questions you have or share your experiences or talk about this or any other OSHA issue. I would be remiss at this point if I didn't also encourage you to please check out our new blog, the OSHA Defense Report, OSHADefenseReport.com. Very proud already of the content we have on there and the great conversations that it has stirred already. And we work very hard at that. Lindsay also spends a lot of time working on articles and content to add to the blog, and it would be wonderful to know that someone other than my mother is out there reading it. So please check it out, and we'll look forward to enjoying conversations with you about information that goes up there, as well as hoping that you'll join us for future webinars. I know we've got, I think, 2 more coming up as part of the 2015 webinar series, and we have been in our war room hashing out topics for the 2016 webinar series, so we'll keep at it. And I really appreciate everybody joining us today, and we'll look forward to visiting with you again on interesting OSHA issues.
Thank you.